Meeting of the committee will come to order. This hearing of the House Oversight Committee wants to welcome our witness, Lurita Doan, the Administrator of the General Services Administration. This hearing is not being held to reinvestigate Ms. Doan's violations of the Hatch Act. Our hearing on negation by the Office of Special Counsel provided an ample record to assess Ms. Doan's compliance with this important law. This hearing will focus on other issues. First, there are serious questions whether Ms. Doan testified truthfully during our first hearing. And there also Ms. Doan tried to intimidate and retaliate against federal employees who cooperated with this committee's investigation. Both issues should be of great concern to all members of our committee. When our committee learned earlier this year that Ms. Doan may have violated the Federal Hatch Act by asking GSA political appointees how they could help our Republican candidates in upcoming elections, we appropriately initiated an investigation. As part of this investigation, GSA political appointees were asked to give transcribed interviews or depositions to this committee. All 6 agreed to come before the committee voluntarily, and all 6 told us about a political presentation at GSA headquarters in January by Scott Jennings, Karl Rove's deputy, at the White House. During that presentation, Mr. Jennings identified 20 Democratic members as targets. In 2000, all 6 employees, Ms. Doan then asked the other for the presentation, how could they help our candidates in the upcoming elections? It was not easy for these GSA employees to come before our committee. Like Ms. Doan, they too were Republicans. They were political appointees, and they knew their statements would be evidence that their boss violated the Hatch Act. And like all employees, they must have feared the potential consequences. That they had an obligation to tell the truth, and they did. As a result of the committee's investigation and hearing, we determined conclusively, in my opinion, that Ms. Doan solicited her employees at GSA to engage in partisan political activity on government property, a clear violation of the Federal Hatch Act. After the March 28th hearing, the Office of Special Counsel, which enforces the Hatch Act, interviewed Ms. Doan about her conduct. When Ms. Doan was asked about the 6 GSA officials who cooperated with this committee's investigation, this is what Ms. Doan told the Special Counsel, quote, "There's not a single one of those who did not have somewhere in between a poor to totally inferior performance," end quote. In her written testimony, Ms. Doan says that she thought her remarks were going to be treated confidentially by the Office of Special Counsel. In fact, she blames the Special Counsel for victimizing the employees by disclosing her disparaging comments. Well, there are just 2 problems with Ms. Doan's position. First, her statements about her GSA colleagues appear to be false. Ms. Doan refused to provide the employees' personal records to this committee. But the Office of Special Counsel did review the employment records and found that all the employees had satisfactory or better performance. It is wrong for a federal agency head to make false or misleading accusations against federal employees. It does not matter whether the official expects confidentiality or not. Unsubstantiated accusations are always wrong. Second, Ms. Doan didn't just disparage the employees. Under oath, she told the Special Counsel, and again I quote, "Until extensive rehabilitation of their performance occurs, they will not be getting promoted and will not be getting bonuses or special awards or anything of that nature," end quote. Apparently, Ms. Doan's position is that it is fine for her to retaliate against her employees by denying them promotions, bonuses, and awards, so long as she does so in secret and no one knows about it. Well, I think she's wrong, and so long as I'm chairman of this committee, we're not going to look the other way when there is credible evidence that federal officials are threatening their employees, especially when these employees are being threatened for participating and volunteering information to the Congress of the United States. We passed, I think unanimously, a Whistleblower Protection Act because we value being able to come forward without fear of retaliation so that we can learn about what's going on in federal agencies, when they misuse their power in those agencies, when they abuse the taxpayers' trust, when they waste taxpayers' dollars. Well, our committee has a fundamental obligation to stand up for federal employees who cooperate with investigators and tell us the truth. And we have an equal obligation, indeed a moral responsibility, to investigate and hold federal officials to account if they threaten to withhold bonuses and deny promotions to employees who tell the truth to the Congress. I'm amazed that anyone would think we shouldn't do that. I'm equally amazed that a few members apparently don't believe it matters very much whether Ms. Doan testified truthfully during her March 28 hearing. I've even heard some members say, so what if she did political activity on government property? What's the big deal? Well, violating the Hatch Act is a big deal. Fortunately,